Good morning, this is your Kelso Report for Monday, April 2nd. I'm your host, Clark Kelso. Today we have a decision of the Ninth Circuit dealing with the area of antitrust law, and then Court of Appeal decisions in the state dealing with public works contracts, interpretation of a commercial real estate contract, and a search and seizure case. Let's begin with the Ninth Circuit and antitrust. The plaintiffs, who were consumers of cable television series, filed a Sherman Act Section 1 claim against programmers and distributors arising out of their decision to market multi-channel cable packages. The complaint did not allege any horizontal agreements among programmers and distributors. Instead, the complaint alleged only vertical tying arrangements pursuant to which a purchaser was required to buy certain channels as a package. Because a vertical tying arrangement of this sort can be fully consistent with a competitive market, the courts require the plaintiff to plead actual injury to competition in order to state a claim under Section 1. Well, in this case, the plaintiffs failed to allege an injury to competition. The allegations that the practice limited the manner in which distributors competed with one another was insufficient, absent any evidence of a horizontal agreement. The allegation that the practice reduced consumer choice was an allegation of injury to consumers, but not an allegation of injury to competition. And finally, the allegation that the practice increased prices was again an allegation of consumer harm, but not harm to competition. So, in Brantley versus Universal Pictures, NBC, the Ninth Circuit affirmed the district court's dismissal of the complaint for failure to allege antitrust injury. Next, we have a case involving public works contracts under California law. In G. Voskanian Construction versus Alhambra United School District, the Second District was confronted with a typical public works dispute between a contractor and the public agency. Can the contractor get compensated for what it believes was extra work beyond the scope of the contract? Well, there were actually two contracts in the case. As to the first one, which was a relocation contract, the Second District held the contractor was entitled to be compensated because the district eventually issued written change orders authorizing the extra work, which were effective retrospectively. As for the second contract, which was a fire alarm contract, notwithstanding the lack of a written change order, the court held the contractor could recover for the extra work that was required because its bid was based on misleading plans and specifications issued by the district. When a public agency furnishes misleading plans and specs, the contractor who was awarded the contract can generally recover for any increased costs associated with that aspect of the plans and specs that are misleading. That benefited the contractor in the case before the court. We have another contract interpretation issue here, this time in the area of commercial real estate. The lender had lent $44 million to borrower, who used the money to purchase two commercial properties and then leased those properties to Washington Mutual Savings and Loan. North Star, an affiliate of the borrower, executed a guarantee that would be triggered by certain defined forms of borrower misconduct. In particular, the guarantee provided in relevant part that, quote, the loan shall be fully recourse to the guarantor, and guarantor hereby unconditionally and irrevocably guarantees payment of the entire loan if any of the following occurs after the date hereof. Roman 4. Without the prior written consent of lender, either lease is terminated or canceled, close quote. Well, as you know, Washington Mutual went out of business, and it and its successors ceased paying rent to borrower and abandoned the property. In February of 2009, the borrower ceased making loan payments to lender. And then in May of 2009, the lender took title to the properties through a non-judicial foreclosure sale in which it bid approximately $11 million. The lender then brought suit against North Star as the guarantor for the balance due on the loan, which was approximately $42 million plus attorney fees and costs. Parties filed cross motions for summary judgment. The Superior Court found in favor of the lender, concluding that Washington Mutual's ceasing to pay rent and abandoning the property constituted a termination of the lease. Well, the second district reversed. The word terminated had a defined meaning in the lease. As defined, the lessee had no power to terminate at all, and the lease could be terminated only if the lessor gave written notice to the lessee that the lease was terminated, which notice was never given, nor was the lease canceled. Therefore, the specific misconduct that allegedly was the trigger for the guarantee, that is, the lessor terminating the lease, never happened, and the guarantee was therefore never triggered. Since the loan was non-recourse as to any of the borrower's assets other than the property itself, and the lender now has title to the property, it looks like the lender has done about all it can do to collect on its debt. Finally, a search and seizure case. The trial court suppressed evidence seized by a second wave of responders who conducted a warrantless search of defendant's home after he had been arrested and the victim was dead. The second district granted a writ of mandate in People v. Superior Court Chapman, directing the trial court to admit the evidence. The defendant had conceded the constitutionality of a search by a first wave of responders who swept through the home after a call by neighbors of shots fired. The first wave officers saw the dead victim and also evidence in plain view. The first wave left a police officer standing by the victim, and the defendant was immediately taken into custody. Within 20 minutes, detectives arrived and re-entered the residence without a warrant and collected evidence that was in plain view. On these facts, the second district held that the police had never abandoned the first search and that the re-entry search and seizure by the second wave of responders was therefore constitutional. The court's holding was supported by both California cases and decisions from many other jurisdictions that have upheld under the Fourth Amendment the warrantless re-entry of a home in order to retrieve plain view evidence previously observed during a valid and proximate entry and search. And that's it for today's Kelso Report. Have a great day in the law.